Okay, guys, I'm repeating this video. I did it before, and for some reason it didn't work. It may splice together a couple of different things, but I'm going to go over agency law real quick, and then I'm going to go over about 3 or 4 things. A couple of them from Chapter 4 that I think you need to know as well, along with we're going to go over the per se rule of reason chart and the Chapter 8 chart real quick on the 4 major labor acts. I'm going to do that all in one video. All right. Agency law on page 97 of your study guide, there are 4 basic parts or 4 different types of agency law. Now remember, an agency situation is basically an extension of contract law. The principle, i.e., and if you think about it like the employer asks the employee to do something. The employee does it on the employer's behalf. The employer is going to be held responsible for the employee's actions. And you learn that a little bit in Chapter 12, and it's an extension of agency law when it comes to Chapter 12 as well. But the basic same principle exists. Principal asks the agent to do something dealing with third parties. The agent does it and is a representative of the principal with third parties. The principal is going to be liable for the agent's actions. This is a common situation in agency law, of which is an extension of contracts as well. Now, there are 4 types of agency law. And once we get through these 4 types, then we're going to quickly talk about the duties, fiduciary duties. And then we'll get into the disclosed, undisclosed, and partially disclosed types of principles. And then we will move on and do some other little things from Chapter 4 and the per se rule of reason and the 4 major labor acts. All right. Under the first agency by agreement. Agency by agreement is where the principal and agent simply agree to act as principal and agent. And when this occurs, this is really going to cause actual authority to exist. Now, actual authority is not listed in your study guide. But it basically says that when actual authority exists, the principal is liable for the agent's actions to any third parties. If there is no actual authority, the principal is generally not liable for the agent's actions. Okay? Well, agency by agreement creates agent authority. It creates that authority right there, the actual authority that we were talking about when we create as agents. And when you have actual authority, it gives you express authority, i.e. the express agreed powers to what you're agreed to. So if Swim were to ask you to drive his car from here to Miami, you may have given that storyline in class, gives your car to take your car from here to Miami, his car, then the express authority would be what y'all agreed to do, how you agreed to do it. Implied authority would be basically like the necessary and proper clause, anything needed to carry out the above express authority. This is going to be called actual authority. All these authorities come under agency by agreement. Now, a typical agency by agreement, if put into writing, is a power of attorney, where the principal gives the agent the responsibility to act on behalf of the principal. Okay? However, it doesn't have to be in writing unless, of course, the statute of frauds applied that we talked about towards the very end yesterday. All right. Agency by ratification. If you look in the first part of the study guide on page 97 of your text, it says a non-agent enters into an agreement. This is the exception, one of the exceptions to actual authority. The non-agent, therefore, there is no actual authority. And if there's no actual authority, there's no express authority, no implied authority, because they didn't enter into an agency relationship. The contract is not entered into by an agent, but rather a non-agent. Therefore, the principal typically wouldn't be held liable in this situation. However, the principal could be held liable after the fact if that principal agrees to what the non-agent did and accepts it unconditionally and says, I will take ownership of what they did, and now the liability or the authority is put on after the fact. So agency by ratification is when there is a non-agent, meaning if your neighbor does something for you on your behalf without your permission, without an agency relationship, you are not held liable for your neighbor's actions unless after the fact you agree to everything and take everything that he represented on behalf of you, unconditionally accept it all in a whole manner. If so, then agency by ratification can occur. Now, this ratification can occur through words. You can just simply say, I agree to what my neighbor did, or it can occur through actions, i.e. failing to disaffirm their actions. If the neighbor says, I did this on your behalf, and you do nothing about stopping them or fixing the situation, then you're probably going to ratify his actions, his or her actions, based upon an after the fact, your actions or conduct by failing to disaffirm. So we're using that ratification disaffirm that we talked about in the element of capacity, dealing with voidable, going from valid or void, depending on which term you use. If you fail to disaffirm, then either through words or actions, that is basically ratification. The third one is agency by apparent authority, also known as agency by estoppel. And if you look, the very first thing it says on page 97, 3A, no actual authority by the agent. This is where the person is not an agent, never was an agent, or was an agent, but is no longer an agent. So here's the thing. So say you fire someone, and during this coronavirus, say you have to furlough some of your employees, okay? Your employee or your ex-employee, because you fired them, continues to do business on the company's behalf without working for you any longer. Would those third parties, those customers that they're interacting with, assume that he still works or she still works for your company? Unless you've told that third parties, those customers, that Jane or Bill no longer works for the company, then they would safely assume that if they're answering the phones or making a contract or a order or something with the business, that they still work for the business. Well, this would be called agency by apparent authority, or also known by agency by estoppel. If that third party is led to believe that an agency relationship exists because they've been fired, there's no agency relationship anymore, then the principal could be led to lead that third party, the customer, to believe that an agency relationship exists. Therefore, because of that, the principal could be held liable for that non-agent, the one that's been fired or furloughed. The non-agent's actions could be held liable by the principal. Now, in that situation, if they are held liable and have to do whatever the contract or whatever you created, the order that you created with those customers as a non-agent that was fired, they may be held liable for that and may have to do it under the terms and conditions. But any money that they lose because of that would then go, they could sue you as the non-agent. You're no longer the agent, you could sue, and the principal could sue, and you may have to pay restitution, damages, or whatever differences that you did. So say, for instance, you worked for CC Creations, and you get furloughed because they just can't afford to keep you on. And you pick up the phone as you're on your last day on the job, and you take an order, and they've already changed their entire pricing system between the time that you emptied out your job, your thing, and they changed the entire pricing system. Will you quote them either a different price or even a cheaper price because you want to give a little FU to CC Creations? So you do that and you give them a cheaper price, and it doesn't match with the pricing techniques that CC Creations has now put in place. Now they're losing money or not making near as much money. Now they may be held liable to that customer for whatever deal you made because agency by apparent authority or agency by estoppel, where CC Creations leads that customer to leave, an agency relationship exists, even though it doesn't because you've been furloughed or been fired. So therefore, but the third party thinks that you're still an agent on CC's behalf. Well, now CC would probably have to honor the contract or honor the agreement between the customer, but then would be able to come after you, the non-agent, for the differences. The other one is if you never worked for the company, but you led other people to believe that you worked for the company, and the company knew that you were doing that and didn't try to stop you. That could also fall under agency by estoppel, agency by apparent authority, which are the same thing. If the principal acts negligently, if he does not stop the agent, if they know about it, they better try to stop that agent. Or if they do, they may be leading the third party to believe an agent relationship exists, and then they would be in trouble, and they would probably have to pay the damages or pay the honor the terms of whatever thing they have with the non-agent and the third party. All right, the last one is agency by operation of law on page 97. This just arises out of a necessity or emergency situation. This would be like a babysitter going to the hospital and signing the forms for surgery if one of the kids gets injured or ill on their watch when the parents can't be reached. Okay, agency by operation of law. Now, the duties owed are going to be on page 98 and 99. Duties owed, the fiduciary duties, there's a bunch of fiduciary duties, but the 5 main ones are duty of loyalty, duty of obedience and performance, duty of reasonable care, duty of accountability, duty of notification. Okay, now each of these he has questions on his regular exams and therefore could have it on this exam. The fiduciary duties are the highest duties imposed upon an employee, like an agent, okay, in terms of to interest in regarding to the principal's interest. The first one is the duty of loyalty. An agent must have a duty of loyalty and place the interests of the principal, i.e. their boss, over their interests of their own. They cannot represent conflicting parties. They can't be a real estate agent for the buyer or seller. Maybe if they've notified both and they agree to it, but they can't do it because the agent for the buyer is trying to get the lowest possible cost, while the agent for the seller is trying to get the highest possible price on that house or that item at auction or whatever. So you cannot represent the conflicting parties because you're not serving to do what's best suited for them. If you're trying to facilitate a transaction, that's fine, but you're not looking out in the best interest for each other. And if you're getting a percentage of the profits, your best interest is to try to get that sale to go through because you're going to get your cut either way. But you're not looking out for the lowest cost for the buyer or the higher cost for the seller. Okay? You cannot be involved in self-dealing, meaning you can't buy the product yourself and then know it's worth more and then sell it later on. Or you know it's going to go up in value, so you have a friend buy it on y'all's behalf and then you sell it later. You've got to look out for the best interest of the principal, meaning trying to find them the best deal, not the best deal for you that works in their minimum standards. So say the minimum standards are you want at least $200,000 for the house. You know a person that is willing to buy it for $250,000 for that house. So you get your neighbor or your cousin to buy it for $200,000. You've done what the principal asked to get at least $200,000 for the house. You get your cut as an agent. Maybe you get compensated and you get your cut. And then you turn around and you sell that house 6, 7, 8 months later for $250,000, making an extra $50,000 in profit. And maybe you act as the agent as well there and you get your cut again. All right. Obedience and performance is the next one. You must reasonably follow directions. So if Swim asks you to drive the car from College Station to Miami, you must follow his explicit instructions on how to do it. If he says, only go to Texaco gas stations and use a Texaco card, only go to Hilton's because I got Hilton Honors Reward Program and I get free hotel stays, so you're going to do all those things. Do not leave the interstate. I want you to drive on the interstate. Don't do farm roads or anything like that in case you get in trouble. Well, if you have to detour off the interstate because the interstate's blocked and or you run out of gas and there's no Texaco within 100 miles, then yes, you have to buy gas from a different gas station or you have to get off the interstate. If there's no Hilton anywhere near when it's time for you to get off the road for a few hours, then yeah, maybe you go to a different hotel. But if you have the capability, you need to do what is expressly told you, obedience and performance-wise. If you violate that, then that is a breach of the fiduciary duty. So if he gives you, if your principal asks you to do things in a certain specific order, and you don't do it in that specific order, then that would be breaching the fiduciary duty of obedience and performance. Okay? And you got to do it in the manner time specified and the manner specified in terms of basically in order of what they wanted. Okay, now on the obedience and performance, you can disobey in an emergency situation or if it violates your ethical duties or violates the law. Reasonable care. You must act in a non-negligent manner. You might have a Mrs. Baird's question on your first exam. If you're driving the Mrs. Baird's truck and you are at fault for causing an accident on the roads within the Mrs. Baird's truck as a driver, then you acted in a negligent manner and thus you breached the fiduciary duty of reasonable care. You could be held responsible. Now, if you're a lawyer, you're a doctor, you're an engineer, that reasonable care standard elevates to the level of your professional standards. But if you violate and are acting negligent, then you breach the fiduciary duty of reasonable care. And if he gives you a storyline about the Mrs. Baird's truck, and I use Blue Baker truck in a lot of my questions with the Mrs. Baird's truck, if you do anything that causes an accident and it's your fault, then it's probably a breach of the reasonable care. You would be held liable because you breached that fiduciary duty of obedience and performance. I'm sorry, of reasonable care. You would be held liable under the fiduciary duties. But the owner of the Mrs. Baird's truck or Blue Baker truck would also be liable because you were acting as a driver. They would then try to go after compensation for you for acting in a negligent manner. The duty to account just means keep accurate records. Don't commingle funds between your private accounts and your business account if you can help it. Trace the money and be able to have a paper trail on all the money or any items that you may have that are under your duties as an agent. You must notify. If there's any changes to the terms, any changes to the situation, you must notify the principal immediately of those changes. For instance, if you're trying to sell a painting and that painter dies, or the value of an antique has gone up dramatically because it's found out that there's less on the open market than before, then you need to notify them so that the principal can accurately reflect a new price system, and then you can go from there. Okay? Because if you do and don't notify them that say the painter died, the painting goes up triple in value and you don't notify them, and then you sell it to your neighbor who then sells it later on for a profit and y'all split the profit, you breach that fiduciary duty of loyalty and also the notification breach duty as well. On the duties of the principal to the agent, if there's compensation to be given, the agents should be compensated for their actions. Okay? Any reasonable expenses that the agent has in doing their business dealings on behalf of the principal, they should have to get reasonable expenses paid back as well. Any losses that the agent has that are not because of their fault, i.e., they didn't do anything wrong, the damages the agent say the third party, the customer sues the agent as well. The agent did nothing wrong in terms of the agency relationship, but they're getting sued. You would have to pay for the agent's financial losses that were not their fault. Now, they wouldn't get anything if they committed a crime or a tort, illegal actions, or misconduct. If they lied to the third party and were told to lie, then yes, you would have to reimburse them. If they lied to the third party, but you told them don't lie because I'm not going to be liable, and they do anyway, then they would not be on the, you would not have to pay, indemnify them for the losses that they incurred if they got sued for that because you told them not to lie. If you told them to lie, you would have to reimburse them. All right. The last thing that we need to go over is disclosed, partially disclosed, and undisclosed principal. Partially disclosed and disclosed. In both partially disclosed and disclosed, the third party knows who the agent is. The difference between the two is in a disclosed principal situation, the third party knows that the person is an agent and they know who they're working for, i.e. in this case, Disney. So say you're working for Disney with the Navasota landowners, they may have given you that storyline. Disney is the principal, you're the agent, the Navasota landowners are the third party. If they know you're an agent and you work for Disney, that is disclosed. If they know you are an agent and you are an agent for Disney, but they don't know it's Disney, then that is partially disclosed because in both situations, they know you're an agent, so they know they're dealing with an agent for a principal and they are the third party, so they understand the general rule there, okay? If the agent has actual authority, there is no contractual liability if it's partially disclosed or disclosed, because then the principal is going to be bound for any third party actions. If the agent has apparent authority, the principal could be bound to the third party and the agent would be held liable. We'll get to that a little bit later on. In an undisclosed principal situation, this is where the Navasota landowners would not know that you're acting as an agent. They think you're just a buyer of their land. You're not working for Disney. So they don't know Disney exists. They don't know you're an agent for anybody else. They think you're purchasing the land. If that's the case, then the agent is liable to the third party, i.e. the Navasota landowners in that situation. And then if the agent is acting and doing everything in the principal's behalf and within the scope of what the principal has to do with them, then the agent can be paid off by the principal for any losses they may have to the third party that the agent is liable for. All right. That is basically agency law. If you remember agency law being big on your exam, I would review that. If you went back and you have exam 1 packets, I would redo some of the questions from agency B as a refresher. Otherwise, you have all these groups of 30s in all the different packets, like litigation in courts. You have some constitution. You have some contracts ones. You have some tort ones. You have some antitrust and all that stuff as well. All right. So that's it for chapter 4. The one thing I do want to go over is I want to talk briefly, and I want you to make sure, I think in the purple packet for part 2, we have antitrust law. And in antitrust law, I do not think we filled in that chart. There's a chart on the areas of antitrust. I think all the acts associated, all the different cases under Chapter 7 are listed in that common law cases, tiers 1, tiers 2, in the red packet that you had. So they're already there with a basic idea of what they do. But we do need to go over the per se rule of reason chart that should be blank right now. Okay. In the per se rule of reason, and let me see if I can find it. I may have put it out into a different folder. Okay. Number 1. Sorry, guys. I thought I had it here. Number 1 is going to be horizontal price fixing. That is per se with exceptions. Remember, Trenton Pottery, Scone Vacuum, Superior Court trial lawyers are all examples of horizontal price fixing. Scone Vacuum, if I didn't say it. It's per se with exceptions. There are certain exceptions. Those exceptions would be the Appalachian Coal case, which was completely ignored by Scone Vacuum. And then you have the NCAA and the BMI cases. The next 2 on your chart are vertical minimum and vertical maximum price fixing. Those follow a rule of reason approach. Then you have horizontal exchange of information. That is rule of reason. Conspiracy to restrain information is rule of reason, but likely going to be illegal, like the FTC versus Indiana Federation of Dentists. And since I can't find the chart, I'm trying to memorize it as well. Hold on 1 second, guys. All right. Towards the end of the purple packet, there is a log sheet. Now, your Chapter 8, the 4 major labor acts, is already filled in, okay? So we don't need to go over that other than I really would know the 4 major labor acts, the formal and informal name. It is also very big on the final exam as well. But the page before that is that log sheet that we're doing. We did numbers 1 through 4. Number 1, per se, with exceptions. Number 2, 3, 4, and 5 are rule of reason. Number 6, horizontal market divisions, is per se. Number 8, vertical market divisions, also called vertical market restraints, is rule of reason. Price discrimination is rule of reason, even including predatory pricing. It would be rule of reason. Tie-in arrangements are per se with a twist. Remember, SWIM thinks it's more of a hybrid rule of reason, and it makes sense if you're going to do predatory pricing under a rule of reason, that tie-in arrangements, tie-in sales, would also be a hybrid rule of reason as well, but it's per se with a twist. Number 10, exclusive dealing contracts is rule of reason. Boycotts, whether vertical or horizontal, are per se, and then mergers are going to be rule of reason. Now, you can go over in depth on Chapter 7, the per se and rule of reason. You can go much more in depth if you look over the Chapter 7 videos. You should, after this video, should have every single chapter is available to the public. I put everything out there, and I'm leaving it out there until the test round is over, and then I'll probably make this this YouTube channel private for the future. But everything is in there. Feel free to email me or text me or DM me in the group me any questions you may have over the next couple of days. I will be checking those religiously And if I can think of anything I want to put on the videos, I will go ahead and put on the videos. Like right now, the one thing I would note from chapter 5, we need to know what repudiation is. Repudiation is where one party, this is chapter 4, sorry, repudiation. One party wants out of the contract, but the other party does not. If both parties want out, it's rescission. Repudiation, one party wants out, the other party does not. Then the innocent party that does not want out is going to be harmed by that. That is repudiation. Remember, rescission and repudiation happen after a contract exists, but before performance is done. Whereas rejection and revocation, our words, are before contract is even created, because those are in the offer stage, offer and acceptance, i.e. the element of agreement stage. So note that as well. If I think of anything else, I may put together another 10, 15-minute video, but I will put a thing on the DM or on the GroupMe to let you know if I do any additional videos. But once again, feel free to email me, text me, whatever you need to do. I'll be glad to answer any questions. I'm sorry this is the way we had to do it this semester. I don't like it. I like the much more interaction and stuff like that. I'm able to gauge a lot more when we go over those questions at the very beginning of each normal review, because it gives me an idea of what y'all are looking at or not looking at. And it makes it a little more easy for me to know what to focus on, whereas here, I'm just focusing on what I think you might need to know versus what you do need to know. Anyway, good luck.